Welcome back to the channel. In another video in this series about this Prince Harry phone hacking trial, which ended the day before yesterday, many people have been surprised that this is not the first time that the Mirror Group has been taken to court over phone hacking, and many people were surprised at the substantial amount of damages that have been awarded in previous cases back in 2015 that we talked about with our good friend Mr. Alan Robertshaw over on Art Media Law, our other channel linked in the description below. So make sure you head over there and subscribe there, support that channel, give it some love, and watch that video because it's really, really interesting as to just how much damages was awarded to each of those claimants in that case. And so I thought I'd come back and do a brief overview of some of the elements within that case back in 2015. So for that, please stay tuned. This is going to be interesting. Welcome back. So let's take a look at that judgment, shall we? So this is actually a redacted judgment because the original one contained some personal information, which was obviously redacted, and therefore it would have been contempt of court to actually publicize that information. But this redacted version of the judgment that you can see here does not infringe those reporting restrictions as ordered by the judge of the original unredacted judgment. Now, this again had representative claimants, and again, they were represented by Mr. Sherborne and the case before Mr. Justice Mann. Now, this is a very interesting judgment in that it goes through various different things. I will link to it in the description below because there's far too much to read out or even go through all of it or even most of it in this video. But one interesting bit that I'll point you to that you might look up is the admissions and apologies section, because until a certain point in time, the Mirror Group had just flat out denied everything. But there is a certain point here from paragraph 19 where it says, until relatively recently, Mirror Group had firmly and publicly denied knowledge of any phone hacking activities and any of its titles. And goes on to explain that there was some admissions and some apologies made in therein. Now, as we've talked about before in previous videos, I've talked about what phone hacking actually is. Now, this judgment also goes in to talk about what phone hacking is. People think of hacking as somebody sitting down at a computer and really intelligently hacking away with code and code flying across the screen as you see in the movies. That's not really what we're talking about here. Far less sophisticated and far less imaginative and interesting. What we're talking about here is way back in the day when phone voicemails just had a default PIN and most people just didn't change it. Or they just made it simple, 1234 or 4444 or 0000 9999 1111 or whatever, and people could guess it. So, word to the wise, make sure you change any of these default things because they can always end you in trouble. And on the note of data protection and privacy, just as a heads up for a bit later in this video, I do have a partner for this video called Incogni. It's not entirely without merit for this video because I'm talking about data protection and how you can protect yourself. More about them a little bit later, but it's very serious, so please take it seriously. Because even when we're talking about hacking, we're not just talking about voicemails and the PIN number as guessing the PIN number, which, by the way, is hacking per the statutory definition, because hacking is any kind of unlawful access to that information. One of the huge blunders with routers, as in internet routers that can give you access or give someone access to yours or their internet systems, is when they had the password set at default, which was admin and password for username and password. Yes, password being password. This, as stupid as it sounds, was the case for thousands of devices across the country, and people simply didn't change it. Now, what you might think of with your own personal router is that they can't really access anything, they can't do anything, but that's obviously not the case. They can intercept communication traffic through your router by using the admin password to connect to your system. Now, I'm not going to go into the intricacies, but it's possible. So again, make sure you change those default settings, please. So let's go back to this judgment here and look at what hacking is talked of in this case, because the general hacking background to all of the claims in these actions. Now, what phone hacking is, as I said, unimaginative and not exactly worthy of Hollywood in terms of the hacking that it talks about here. This goes on to say exactly what I've just said, only in much longer form, as you would expect from a judgment and any kind of lawyer or judge. A mobile phone account comes with a voicemail box, which the account holder can receive, listen to voicemails left by callers when he or she does not answer the phone. The messages can be retrieved by the phone itself or by ringing from an outside line. The mailbox can be protected from an unauthorized person ringing and listening to the voicemail by a PIN code. At the time of the events covered in this action, some of the mobile phone companies had default PIN codes. Many users did not bother to change them, if indeed they knew they existed, which is a very important point because many people with a router at home may not even know that your router has an admin password to access said router. Same goes for your phone and your voicemail, I dare say. Other users changed the PIN codes but used codes that were predictable. 1234 11112222 1122. If you've got an interested enough reporter, they are going to take time to find out what that PIN code is. But that's not all. There was a slight variation on this. Still not worthy of a Hollywood blockbuster, but there are two ways to which unauthorized persons could access another's voicemail. One of which would be ringing a different number, which then gives you access to that. I think it was Orange it mentions that had that facility. And another one, which was quite interesting, which is mentioned in this judgment, is where they used two phones. Now, this is only very slightly more imaginative, but it was very interesting nonetheless, is they would use one phone to ring the victim's phone and then another one to ring immediately afterwards. But then the first phone would hang up, so not even to ring the victim's phone and to alert them to the fact that it was being called. But the second one would get through to the voicemail. And then by getting through to the voicemail, a few codes or whatever, star hash or whatever it was, would get them access to the voicemail PIN system, and then they have an opportunity to guess that PIN. So that's what we meant by hacking, even in the case way back in 2015. But then we come to the findings of fact in this case in 2015, where the judge considered each an individual claim and made findings in respect of each of these, and said that in relation to the 7 claimants who were on Mr. Evans' back pocket list, they will have been hacked at least twice a day. That was the purpose of this list. There will be more frequent hacking if the regular calls or other factors alerted journalists to potential stories. So let's take a look at some of the articles and what actual damages resulted from those articles, because after all, it was a severe breach of privacy that was found by the court and thus awarding damages. Talking about Paul Gascoigne, in this particular instance, there were several claimants. Obviously, this is a lengthy judgment, many hundreds of paragraphs long. It talks about Paul Gascoigne from paragraph 572 in respect of the findings on damages. It says, Mr. Gascoigne tended not to focus on the specific effects of individual articles in terms of the effects on him. His evidence concerned a more global effect. In order to reflect that, I shall still deal with each article separately and attribute damages commensurate to the invasion of privacy which it constitutes, taking some articles together, but not build in particular amounts for distress or upset arising from the particular article. I shall take account of upset and distress in wider global assessments for that part of his damages. The effect of the decision not to cross-examine Mr. Gascoigne, because that was an interesting point, because actually when he walked out of court, he was showing some kind of surprise and emotion that he wasn't going to be cross-examined in court. The judge said that the effect of that was that various matters, which I can well imagine might have been canvassed with Mr. Gascoigne in order to determine the real level of disclosures relating to certain parts of his life, were not investigated with him. Article 1, the judge goes on, were it not for the admission made in relation to this article, it might be difficult to find that it would not have been published but for unlawful activities. The bulk of the article apparently comes from a third party and does not involve Mr. Gascoigne at all, and it is hard to see what parts of it had their genesis in unlawful activities. However, I cannot ignore the admission, and the article does refer to his stay at a clinic which is capable of being private. Mr. Sherborne sought to rely on the threats as being private material. I received no argument on that. My view is that it probably is. Mr. Gascoigne should receive £7,500 for this article, principally because it does refer to the private matter of treatment at a clinic. Article 2, the judge goes on, these are just by way of example. This was intrusive reporting of a holiday with references to his treatment before it. This holiday was not, as submitted by Mr. Nicklin, a public matter. It is likely that newspapers found out about it by intercepting voicemails. It attracts compensation of £7,500. So just to give you an idea, each of these articles that were published, either with admissions or findings, were attracting something in the region of £7,500 per article thus far. Article 3 was a repeat of information, and the judge said that he would take this into account when assessing global sums at the end of this section. Article 4, the financial detail that appeared here was something known by Mr. Gascoigne and his agent. It must have been acquired by unlawful means. So just to draw a parallel here with the Prince Harry case, whilst there was not hard evidence of what had happened, the judge came to the conclusion that this was private information and must have been acquired by unlawful means. So this, as I say, is not direct sort of CCTV or record information of someone doing something unlawful. Clearly, if they're doing something which is unlawful, they're going to be doing it covertly, covering tracks and so on. But the judge made the finding that it must have been acquired by unlawful means and that the dinner was a private event known only to his ex-wife. And this whole double intrusion attracted compensation of £10,000. So you can start to build up a picture here that each of these articles that the judge either takes admission or makes a finding is making orders of compensation for £7,500, a global consideration, and now £10,000. Article 5. Some of the material in this item is plainly capable of being private. Mr. Gascoigne believes that the information in the article was obtained from hacking. The judge goes on to say it is unlikely that all material in this article was treated as public by Mr. Gascoigne. Viewing this matter realistically, I consider this article attracts compensation of £8,500. And then another couple of articles where he dealt with the articles globally along with other articles. Now, I'm going to go on to talk about a few more general points about data protection and hacking and how it might relate to the Prince Harry case. But first of all, as I mentioned earlier, a brief word on my partner for this video called Incogni. If you take your data protection seriously, as I do, you'll be interested in the service that they offer, because I use Incogni to help to remove my personal data and information from a great many companies that will be selling my data onto other parties. Now, many of you might think that this is just perfectly harmless. It's just your name and there's nothing really that happens. But trust me, I will tell you in just a moment why it is really important that you do take these steps to protect your personal information. You see, you can think of yourself as some kind of jigsaw puzzle, with your name, your address, your date of birth, your driving habits, maybe even your driving license number, maybe even your insurance details, what you browse online, things that you buy, things that you discuss with friends, where you go, where you travel to. All of this information is contained on a multitude of different servers, and it can all come together to form a jigsaw puzzle of you. Why is that important? Because marketers will pay for that information. They will pay for it for a number of reasons. They will pay for it because they want to market products to you. They will pay for it because they want to sell it on to other people who have nefarious intent. Now, some people will buy this, as in some companies will buy this information just to market their products to you. You might think that that's perfectly fine, and I don't really have a problem with that. What I do have a problem with is the nefarious actors in the market to whom this information will be sold once it's been sold once or twice over. And that will increase the risk of this information, your information, ending up on what we call the dark web. The dark web is as bad as it sounds. It is the dark side of the web, the internet. Your information, all of that information, if you were to open a drawer next to you that's got all of your personal files in it, if that information were contained on a database somewhere and they were selling it to other actors, think of the worst possible company with the worst possible intentions having your information and what they might do with it. Now, Incogni is a service which will force any of these middle companies who are selling your data to remove your data from their systems. They do that by enforcing your data protection rights. Now, if I were to task you with going to find these companies and ask them to remove your data and your information, I would expect that you'll find that quite difficult. Even as a lawyer, I would find that difficult because there are dozens and dozens of these companies. You can see from the report that I'll put up on screen now. This is the report that I received just a few days ago because I am personally using this service. And here's another report from several months ago, and it's taken that long. It has taken months for these companies to respond and return a positive action that they've removed my information from their databases. They've confirmed that my information was on their databases and that they've removed it. But the problem really comes here, in that you might be perfectly happy for 1 or 2 companies to have your information, but once it's been sold 2 or 3 or 4 times over to different people paying the highest bid for your information, it will ultimately end up in the hands of someone working within the dark web. And there is where we get the real trouble, because they are not looking to market to you. They are looking to clone you, to steal your identity, to create an account in your name with banks, with credit card companies, with loan companies. You may have heard just recently that even Nigel Farage has had the bank close down his accounts for reasons they won't give him, because the banks are not obliged to give you a reason if they shut down your bank account. One of the possible reasons that they do that is if they suspect fraud. Obviously, not on Nigel Farage's behalf, at least insofar as I'm aware, but if someone who is copying his identity and attempting to open accounts in his name, by way of example, then the bank might suspect that there's fraudulent activity which is going to affect the bank because they're pretending to be him. Now, the bank may take the choice to close down all accounts in that name because there's a bad actor with that name committing fraud and the bank is taking no chances. Now, if you end up in that position, as some of our clients have in the past, your life can be totally turned upside down because you'll have no bank account, no credit card. Even your mobile phone companies might shut down your account because you might end up on a fraud database. All of which can be avoided if you sign up to Incogni with the link in the description below using my unique discount to allow them to do all of the work for you. Now, as I said, you would find it difficult to find these companies in the first place, but Incogni will do all of the work for you. Once you sign up, you give them your information and they will take it and go to all of these companies and insist that all of your information is removed from their servers. And as I said, this takes many, many months and they have to go back and forth. Some of these companies argue back and forth that they don't have to remove your data, but Incogni will go back and insist that they do. If the company comes to you, you just forward it back to Incogni and let Incogni do the work for no additional fees, not like paying a lawyer, such as me. You'd be paying hundreds of pounds an hour for a lawyer to do exactly the same thing for you. For a very nominal sum, you can get Incogni to do all of this work for you using my unique link, which is on screen and in the description below, with a discount to save you a lot of time, hassle, and stress by allowing Incogni to do all of this work for you. It will help to remove your information from these companies, avoid the risk of it ending up on the dark web, and avoid the risk of you losing access to bank accounts, credit cards, loans, and all kinds of other facilities that can wreak havoc on your life. Trust me, as a lawyer, we have had clients in precisely this position, and there's very little we can do about it. I've written letters to the banks to say this is unjust, you need to undo this, you need to restore my client's bank account, and the bank simply did not even respond because the banking laws allow them to close accounts if they suspect fraud on any level and they don't have to explain it to you. So do yourself a favor. I urge you, not just because it's a partner to my video, but because I use it myself and I would never recommend something to you that I don't use myself. Use the link in the description below, sign up, have them remove your data, and feel a little bit more at rest. So thank you for letting me talk about my partner, and now back to the main video. So now taking a look at Prince Harry's witness statement in this instant case, which closed the day before yesterday, Harry is talking about 50 newspaper articles which he says contains private and confidential information relating to him and his associates that was not publicly known, which he now understands may have been obtained unlawfully, and therefore he deserves compensation. Now, out of 50 articles, quite clearly, simple maths tells us that even if only, let's say, half of them, 25 articles, attracted only £5,000, clearly, that's £125,000. But if they attracted more in the region of £7,500, then he'd be up at close to £190,000 or 187,500. If 40 articles would attract the £5,000, clearly we'd be up at £200,000 in damages. And you can see from Appendix 1, the list of documents here, it refers not just to call data and private investigator invoices and things like that he's used to support the claim, but also a list of the articles which he's complained of. So let's take one of these articles here and have a look at why Harry says that they had private information and that it could have only done so by unlawful means. This article was titled 3 a.m. Harry's Time at the Bar. This was the Mirror on the 19th of September 2000. It says here in his witness statement, this article contains details of a lunch I had with friends at the Ifield pub in Chelsea to celebrate my 16th birthday. There's an interesting point about him being 16 as well, because the age of somebody in an article will always have some bearing on how a court views it. It was published on page 19 in the Daily Mirror's 3 a.m. column, written by Jessica Cullen. It says, I don't know how anyone would have known I was at this particular pub at this particular time in order to be there taking photographs of me. Based on what I understood at the time of how public engagements worked and the security measures in place for me and my family, I always found these kind of coincidences to be odd. I now understand that the byline journalists and the 3 a.m. desk as a whole are well known in this litigation for being involved in phone hacking and other forms of unlawful information gathering. My solicitors have advised me that many 3 a.m. articles authored by Ms. Cullen have previously been admitted by the defendant to have been the product of unlawful information gathering. He says, what strikes me about this article in particular is the comment that a week before, I'd insisted that one of my PPOs, personal protection officers, had joined me and a friend when we had lunch at Pizza Express. I'm unsure of how the defendant's journalist would have been aware of any private conversation between me and my PPO, but it's notable because it's another example of the defendant seeming to know where I was at a particular point in time. Private visits to restaurants with friends were never publicly announced. In fact, our movements were always intended to be kept secret, which one can understand for someone in the royal family. Nor did this kind of thing fall within any official duties. Yet not only did the defendant seem to know where I was at all times, they felt able and entitled to report it to the public without any regard for my security or any private life I wished to have, even at the age of just 16. So, for those of you that are against Prince Harry in this case, take that aside for a moment. Imagine, take any kind of 16-year-old who has any kind of publicity and have a journalist following them around knowing where they are. That in and of itself raises questions, but particularly if they were doing so using unlawful means, which is something the judge is going to consider here. And bearing on the previous case with Paul Gascoigne and other representative claimants in the 2015 case that I was talking about, the judge may well draw inferences on what has gone before. One final example I'll give you is this one here, which was Snap Harry Breaks a Thumb Like William, exclusive, The Mirror, November 2000. Harry says this article, which was published on page 11, reported that I had a chipped bone in my thumb. My solicitors have shown me documentation that suggests Jane Kerr had previously instructed Jonathan Stafford, a private investigator known to have undertaken unlawful information gathering activities, to obtain extra details for her. The article stated that I had my arm in a sling after having a minor operation following an accident during a game of football at school. It stated that a friend fell on me during the game. The article included a comment from a palace spokesperson, which according to the article was given after my father had visited me and stated that the injury was thought of at first as only bruising, but a precautionary x-ray led the surgeon to recommending a minor operation. Harry says the article itself reports that receiving a comment from the palace contrasts with the previous account taken by my family, whereby my father, he says, had made a complaint to the Press Complaints Commission after the defendant had reported on a rugby injury I'd sustained. Again, it seems to me that the palace may have been approached for comment rather than a proactive statement being released, although I can't be sure of this. The level of detail in it is just surprising, as is the specific comment made by the defendant's journalist that I had been told by doctors not to play football for a few weeks. This isn't attributed to the palace spokesperson, which seems odd, although any comments from the palace would have been strictly need to know. I certainly didn't want any information about injuries I'd sustained being reported so publicly. They weren't life-threatening. They were routine childhood injuries, the odd broken bone. I was often teased at school, largely as a result of this kind of article. So this paragraph here also supports what I've said before, in my view, that Prince Harry is possibly taking the view that for so long and for so many years, journalists have reported every slightest little detail about him, despite, as he says, his father, now King Charles, of course, making a complaint to the Press Complaints Commission after details of his rugby injury were published. And he may well have just decided, well, let's put it all in a book. Now, of course, many of you may still disagree with that, but that is very possibly one of the reasons he's done that. But this is just a few examples of those articles compared with the 2015 case, because many people in the comments were surprised at the level of damages that each of those claimants were awarded and what may well be awarded if Prince Harry goes on to win this case. Now, just to summarize, in the examples I gave you with Paul Gascoigne, he won £188,250 in all of the phone hacking, which again was against Mirror Group newspapers in the High Court in 2015. Again, it was a group of representative claimants, and again, we are back there once again with similar kind of complaints, similar kind of arguments, similar articles, similar alleged unlawful activity. So you can now see why it's possible that Prince Harry may well go on to win this claim, even though there is not direct evidence as to what he says happened, only that the articles show that they would have had access to this information, and therefore the only way they could have had that information would be unlawful means. So drawing those two together, hopefully you can now see that there is some way, at least, for Harry and the others in this claim to succeed on that claim, even without evidence. I thought you might find that interesting, so please smash the like button if you found this in any way interesting and enlightening and entertaining. Please do subscribe and hit the notification bell, because around 60% of you don't, and I'd be really grateful. That's all I ask of you. Please subscribe, please share the video with somebody. Thank you for letting me talk about my partner for this video, which I wholeheartedly believe is in your best interests to protect your personal data. So again, check that discount link in the description below. And for now, thank you for watching, and I will see you all next time.